Now, foreclosure defense today really is a hot area. It's a niche practice. Rob kind of stole my my reference to what it is. I look at foreclosure defense truly as the flavor of the month. It just happens to be the hottest area right now where everybody can jump in and try to do something. I've got a lawyer in Naples who is responding to a complaint that I filed for a lender that I represented. He's been practicing 3 months, didn't know what he wanted to do, and decided to do foreclosure defense, and he pilfered somebody else's pleadings, and I called him on it, and he had no idea what really he was referring to in his defenses. So it's important to be knowledgeable in whatever area of the law you're going to be going into. Now, once you get a foreclosure matter in, one of the things I try to do is educate my clients about some of the statistics out there. Right now in the state of Florida, 90% of all foreclosure cases, the borrower goes unrepresented. 12% of all real estate sales nationwide right now are short sales. And typically, nationwide, a short sale can take up to 9 months to complete. Most borrowers, and this might be the reason that most don't go represented, they don't think they can afford an attorney. But typically, the cost of legal counsel in foreclosure will be less than the rent they would pay on an apartment during the course of the case. A lot of these matters don't cost thousands and thousands of dollars to litigate. And if you've got a good defense under federal law, the bank may be paying you fees at the end of the case anyway. But if it's a motion or two a month, if that, it's a few $100s a month to a client that if they stay in their home, they pay you to defend the case. It's a better bargain for them, but most people don't know that. People ask, what is foreclosure defense? In my practice, and it's more than just handling a foreclosure suit. It involves counseling the client about pre-foreclosure alternatives or even the same alternatives once there is a foreclosure. Loan modification, reinstatement, short sale, deed in lieu of foreclosure, last resort bankruptcy. Unfortunately, in my office, most of the clients don't come through the door until they've been served with summons and complaint. The way I handle them is very important intake. I want to make sure that the client comes in with all of the relevant documents to their mortgage loan. They've got their closing package from their original closing. That's probably the best piece of best set of documentation to have, and I'll explain why in a moment. Want to find out, again, expectations. If they come in and say it's a matter of life or death, it's not. And they need to understand that. Because if it's a matter of life or death to them, they're going to be calling you every day. And they're going to be wanting more than they actually probably can achieve, or that you can achieve for them as their attorney in the case. And you need to decide, is it a client that I want? I have lots of people who walk through my door, foreclosure and short sale matters, that I listen to what they have to say, listen to their expectations, I try to counsel them on what's a reasonable expectation, and at the end of the day I refuse the engagement just because I know from experience it's not going to be a good relationship. When I meet with a client, I do want to have the entire closing package, and I want to look at can the client afford to keep that property? What's their financial situation? Does somebody have a job? Is there income? Is there something that if we're looking at a modification, it can happen? Is there equity in the home? If there is, that tends to provide another idea to go to the lender with about how to deal with modifying a loan or even short selling. So many short sales out there. They have a house that has equity. If you needed to sell it, you could actually walk away with money in your pocket. It's somewhat of a rarity today, but it happens.
Scott, could you explain for those who may not understand what it means to do a short sale?
Sure. A short sale is a sale of a piece of property where the value of the property is less than the mortgage amount. If I've got a $200,000 mortgage on my home, and because of everything that's happened in the market, the property is only worth $125,000, or that's what's being offered, I'm upside down. Banks out there will allow for short sales where the payoff is going to be less than the mortgage amount. And what we try to do in those is make sure that the client's off the hook for the balance. That banks will allow those to happen takes some time to go through the process, mainly because of the lenders. And there's no standardized program from lender to lender. So if I'm working with lender A, they may want to do it one way. Lender B is going to be something else, and it gets me frustrating for both the lawyers and the clients. But we have to be diligent, pushing through the process, working with lenders, and making sure that your seller, if you're on the buying side, doesn't do something remarkably dumb like filing for bankruptcy in the middle of the short sale process, because now you have the bankruptcy courts to deal with. I just finished a short sale that took 14 months, primarily because the seller filed bankruptcy, ill-advised bankruptcy. So those are all options we'll review with the client to see what they want to try to do and how to best get there.
I have a quick question.
Yes.
If someone came in and you determined that they really didn't have the capability to pay for the property, would you advise them to retain you and defend them in the foreclosure, or is kind of sort of all lost at that point?
Well, no, it's not all lost at that point. We still try to find a way to help a client keep their property, even if the cash flow is not there. For a modification, especially with the Obama Making Home Affordable plan, there are a lot of different things that a lender will look at, and a lot of different things that the plan recommends lenders do. Reduce the principal outstanding, reduce an interest rate, go interest only for a period of time, and not have it as a negatively amortizing loan.
Which would reduce the monthly payment.
Right, until somebody gets back on their feet. I just accomplished one about 2 weeks ago where we agreed to a flat fixed interest rate for the life of the loan, that it was going to be at 5.25%. The first 5 years are interest only. So the amount of the payment went down substantially, gives these people an opportunity to really get completely back on their financial feet, keep their home, make their payments, and then hopefully 5 years from now on it becomes a amortizing principal and interest payment loan, they can afford to make those payments. And the other thing about the Obama plan is if somebody is able to succeed in that plan, the banks get $1,000 per year for every year that the loan stays in the modification process, and the homeowner gets $1,000 a year accredited to their principal balance for every year they're up to 5 years that they're in the plan. So there are alternatives even while you're in foreclosure. I have a lot of clients that are in foreclosure who are working modifications at the same time. The other thing that's recommended by the Obama plan is for lenders to cease all foreclosure activity while the modification is in process. That buys time for the people as well to try to get on their feet, not have to worry about defending a lawsuit at the same time. Now, when they come into my office and they've got their foreclosure papers in hand, and gone through an analysis of what the options may be, we still have to deal with the foreclosure. So the first thing we do is, of course, we review the complaint and the note of mortgage, which are supposed to be, but not always attached. A lot of these cases are filed by probably one of maybe 4 or 5 foreclosure mill firms that are located around the state. 2 are here in Broward County. Those firms tend to employ fairly young, inexperienced law school graduates. If you're looking for a job, some of these firms will definitely hire you. They may not keep you on after a year, but they will hire. But what they have, and I have a former staff member who's working at one of these firms, pigeonholed doing one particular task, and she's told me that pretty much there's a timeline and flow chart of you do this on this date, you do this on this date, this is the flow chart. And if something is filed that's outside of that flow chart, it really slows things up. A lot of these firms just don't react to it. I have a case that I filed a motion to dismiss in almost a year ago. They've done nothing. I have another one that, yes.